Good afternoon, and thank you for tuning in to our Q&A video. We'll be discussing the Supreme Court's upcoming oral argument in Students for Fair Admissions versus Harvard College. This case involves challenges to affirmative action in higher education, and I'm excited to be joined today by Professor McClellan, who served as the founding director of the Advocacy for Racial and Civil Justice Clinic at the University of Pennsylvania Law School. Prior to joining Penn, Professor McClellan has represented students and families in school desegregation cases and students and alumni as the amici in SFFA versus Harvard, defending Harvard's affirmative action admissions policies. Sorry, one sec.
No worries.
We wanted to have this conversation to spark more discussion on Penn's campus regarding one of the many important cases that the Supreme Court of the United States will hear in its current term. This is the Students for Fair Admissions versus Harvard case, where oral arguments will take place on October 31st. So I wanted to start off with some helpful background discussing the current landscape for race-conscious admissions in higher education.
Sure. So first of all, thank you, Karla, for that introduction. I should say that Karla has also been engaged in doing research around affirmative action and as well as civil rights more generally. So glad to be in conversation with you today. So the Students for Fair Admissions case really has two different sets of claims. The one that often is talked about is the discrimination claim, in which the plaintiffs have alleged that they are discriminated against in admissions. But separate from that claim is also a challenge to race-conscious admissions generally. And that is a direct challenge or attack on over 40 years of precedent, in which the Supreme Court has said repeatedly that race can be considered as one of many factors in admissions, so long as the consideration of race is narrowly tailored to serve the compelling interest of pursuing the educational benefits that flow from diversity. So the Supreme Court has said this again and again, most recently in Fisher versus University of Texas. And through these decisions, we've come to understand what the framework is for complying with the narrow tailoring requirement. And generally, the court has told us that the consideration of race cannot be through a quota. You can't have a specific number that you're targeting, but there can be a more flexible consideration of race through a holistic admissions process. It can't unduly burden non-minority applicants. It can't insulate underrepresented minority applicants from competition with other applicants. But it can be considered to pursue the educational benefits that flow from diversity, including universities can target a general goal of having what's referred to as a critical mass of underrepresented minority students. And that is to avoid stereotyping, to avoid tokenism. And so these goals are all goals that have been affirmed over and over again by the Supreme Court. To be narrowly tailored, a university also has to show that there's no workable race-neutral alternative that could achieve the educational benefits of diversity. So the university, should have considered, for example, through scholarships, through recruitment strategies, through looking at socioeconomic status, or through other race-neutral strategies. Could we use those alternatives and still achieve similar levels of diversity, or is it necessary to consider race as one of many factors to obtain the educational benefits of diversity? And research generally in the higher ed space has shown that, not only what is logically true, that nothing is as effective at creating racial diversity as actually, explicitly considering what you're pursuing, but that these race-neutral alternatives are not as effective in action. And so that's something that was at issue in the Harvard case as well.
Okay, thank you so much for providing that context. It's extremely helpful. And I was hoping that we could just dive right into the SFFA versus Harvard case. If you could talk a little bit more about who's behind the suit and how did this case come about?
Sure. So behind the suit is Ed Bloom, who is a former stockbroker and who has become the architect behind multiple attempts to challenge race consciousness in different areas of the law. So he's perhaps most well known as being one of the architects behind the Shelby County decision, which gutted the Voting Rights Act. He has generally pursued this agenda of making sure that policies that are designed to ameliorate racial inequality are in different ways gutted by not being able to consciously consider race anymore. So after Shelby County, he turned his attention to affirmative action as another context where race-conscious remedies are pursued to address inequities or to pursue diversity in the higher ed context. He teamed up with Abigail Fisher, who folks may remember from Fisher v. University of Texas. She was the plaintiff in that case. She is a white woman who argued that she did not gain admissions to the University of Texas because of her race, because of race discrimination. And so she, along with Ed Bloom and her father, founded an organization called Students for Fair Admissions. Before the Supreme Court had ruled on Fisher v. Texas, Ed Bloom was already recruiting for plaintiffs for the next challenge to race-conscious admissions. And in fact, he was actually going into different meetings and explicitly saying, I need Asian American plaintiffs. And to really understand, why he had zeroed in on pursuing Asian American plaintiffs as a strategy for the next challenge to race-conscious admissions, it's important also to look back at the oral arguments from Fisher v. Texas, and of course there was both Fisher 1 and Fisher 2, but also the opinions of Justice Alito and Justice Thomas, who raised the issue of, they said that race-conscious admissions must discriminate against Asian Americans, that it must have this zero-sum effect where Asian American students are penalized. That was not actually an issue in Fisher v. Texas, and there wasn't evidence in the record on this issue because Abigail Fisher's claims were not about Asian Americans. They were about her own alleged discrimination. But Abigail Fisher and Ed Bloom, following the Fisher decision, really latched on to this concern of discrimination against Asian Americans, or this narrative, and that was part of the strategy behind forming Students for Fair Admissions. One can surmise by the series of events.
Okay, and could you also talk a little bit more about what exactly is happening in the suit? What were some of the claims? And if you could just walk us through that, that would be extremely helpful.
Sure. So first, as we've talked about, is this direct challenge to 40 years of settled law, holding that colleges and universities may consider race as one of many factors in admissions to assemble a diverse student body, and to yield the educational benefits of diversity. So they're directly challenging this precedent, which is pretty unusual, right, for the Supreme Court to grant cert on a question that has been decided recently and has been decided repeatedly, but they are directly challenging this precedent and asking for a change in the law. Separate from that, they also have a series of claims where they are alleging that Harvard does not comply with the precedent as a matter of fact. And so as we talked about before, narrow tailoring, the Supreme Court has said means that you can't use race as more of a plus factor and that you can't engage in, what SFFA has called racial balancing and others refer to as racial balancing. And so they have claims that essentially say that Harvard is not pursuing the educational benefits of diversity in a narrowly tailored way. They also have a claim that Harvard failed to use and consider race neutral alternatives. Again, this goes towards narrow tailoring. And then they also have a claim that Harvard discriminates against Asian American applicants. It's really important to separate out these claims because they're often, kind of wrongly conflated, but they're actually separate issues, and it's important to consider them as separate issues because otherwise, part of their strategy has been to conflate the issues and to create this narrative that considering race in any way per se or must cause discrimination. And really, when you look at the statistics and the studies that have been done, that's not true. It's not as a matter of numerical or statistical accuracy the case that considering race as a plus factor for Black and Latino students leads to less Asian American students getting admitted to college. But by conflating these issues, they've been able to create that narrative despite what the numbers show.
Okay, and could you also talk a little bit more about Harvard's admission process? What does that look like? And I think it's helpful that you are, separating the different claims and reminding us of not to conflate. And so I think it could be helpful for us just to dive a little bit deeper into what Harvard's admission process looks like and go more into that.
Sure. So during the trial in Students for Fair Admissions v. Harvard, we learned more about Harvard's admissions process. There was a 3-week trial, and the court actually heard testimony from 18 current and former employees at Harvard, 4 expert witnesses, and as we'll talk more about, 8 current and former students who testified as amici. But through the testimony of Harvard employees, we learned about the considerations that make up Harvard's admissions process. So some may not surprise you, right? There's the academic rating that students receive based on their grades and their test scores and their academic accomplishments. But there's also many other things that Harvard considers as part of its holistic admissions process. So it considers an extracurricular rating, which includes involvement in clubs or leadership positions, athletic rating, which considers students' involvement in sports, including, whether they would participate in club sports and other activities on campus. And then lastly is the personal and school support rating. And this is based on a student's ratings based on their referrals from their counselors or administrators at their school that they're applying from. It's also based on their essay or personal statement. And it's a way for the university to get a better understanding of how would this student contribute to the community at Harvard. So all of these things make up the holistic admissions process. And it's important to remember that what students are being graded on when they apply is not just grades and SATs. Because in fact, there's too many people who apply to Harvard who have a perfect SAT score and perfect GPAs to admit. So it can't be the case that that's the only thing that's being considered. There's just not enough seats in each class to admit everybody who has a perfect SAT score or a perfect GPA. In addition to the fact that you can imagine that students learn from having a class that is made up of people who have all different types of gifts that they're bringing to the university community. So the admissions officers are creating ratings based on all of these categories There's more than one admissions officer who's reading each applicant's folder. And then ultimately they're assembling a class based on multiple reads in different committees of applicants' entire admissions file.
Okay, that's helpful to just have a better understanding of what that process looks like. And I also want us to dive in a little bit, talking about the experts that were used in this case. So I was hoping that you could talk more about SFFA's expert and then talk about Harvard's expert and how they analyze data in this case.
Sure. So the district court judge, Judge Allison Burroughs, actually talks about in her opinion how much this case became a battle of the experts. And although both the expert for Harvard, Dr. Card, and the expert for SFFA, Dr. Arcidiacono, looked at the same data in terms of the applications they considered. They looked at 6 years of data for over 100,000 applicants. What they considered in their analysis when they actually conducted their regression analysis was very different. So the main differences are that Dr. Card included in his analysis what's called ALDCs, and that's how they became referred to during trial. But that essentially includes athletes who go through a different admissions process because they are recruited athletes, legacies who also, go through a unique admissions process because of the plus factors that are given to legacy applicants, students on the dean's list who have been flagged by the dean for different reasons, and children of faculty. So the acronym that was used during trial for this category of applicants is ALDCs, and ALDCs actually make up 30% of the admitted class at Harvard. So this is a significant proportion of who actually gets admissions. But in the analysis that Dr. Arcidiacono conducted, he excluded all of the ALDCs. So he excluded almost 30% of admitted classes or admitted students to each class, and that impacted the results. Another difference is that Dr. Card analyzed each year of data separately, and that's because, as anyone who's applied to college knows, you compete against the people who are applying that year. So that's kind of the relative pool for each year's ultimate analysis of who's admitted. But Dr. Arcidiacono did not look at each year separately. Instead, he pooled all 6 years together. And then lastly, Dr. Card considered things like the concentration of each applicant, what they were planning on majoring in, their parental application, their alumni interview, and most importantly for our purposes, the personal rating. In contrast, Dr. Arcidiacono did not consider the personal rating in his analysis. And the reason he said that he did not include that rating is he said that it was biased because Asian American applicants receive a slightly lower personal rating overall in the aggregate. But it's important to remember that the personal rating is part of the admissions process. And so to remove that rating from the analysis removes part of the factors that are actually considered for admissions. So not surprisingly, because they considered different data, they had different inputs into their ultimate regression analysis that they ran. And they reached different results. Dr. Arcidiacono ultimately reaches the conclusion that there's a slightly negative correlation between being Asian American and being admitted to Harvard. And Dr. Card reaches the opposite conclusion. And so their analyses, their expert reports support SFFA's claim or contradicts SFFA's claim in different ways, right? Dr. Arcidiacono's study, his regression analysis that he conducted, in his expert report provide support for SFFA's claim that Asian American applicants are discriminated against, whereas Dr. Card reaches the opposite conclusion and therefore finds that there's no evidence of discrimination against Asian American applicants.
Okay, thank you for providing that information. It definitely sounds like the battle of experts, so it was really helpful to have a better understanding of the different ways they analyze data. And I wanted to also discuss something that you hinted at a little bit earlier, in particular, how essential student voice is in this discussion. So if you could just talk to us a little bit about the amicus plus status that students were granted and your experience with hearing some of the student opinions on this matter.
Sure. So when I was an attorney at the NAACP Legal Defense Fund, we represented over 25 student and alumni groups as what was called amicus plus during the trial. And this, is a unique status. It's different from having amicus status where you do, for example, an amicus brief, in that the students and alumni were actually able to participate at trial. They were able to give testimony, and we ultimately gave a closing argument on their behalf, and participated in the trial beyond just briefs. And so this was important because otherwise, too often there's not a real opportunity for student and alumni voice in challenges to race conscious admissions. And so the people who are most directly impacted, the students who are on campus and who are experiencing the educational benefits of diversity, don't actually get to have a say. So it was really important to the students and alumni that we represented to be able to participate in trial. It was also particularly important because, as we talked about, Students for Fair Admissions is claiming to represent Asian American students. It was important to the students we represented who were Asian American that they actually have a chance to speak during trial and speak for themselves. In contrast, Students for Fair Admissions, as I said, it's an organization founded by Ed Bloom and Abigail Fisher, but it claims to have members who are Asian American. And yet none of the people who spoke during trial were actually Asian American on behalf of the plaintiff. So there was never a student who came forward and said that they were discriminated against. There was never a student who testified that they were a member or that they were impacted and disadvantaged in the application process. In contrast, the students who we represented spoke about the ways that the educational benefits of diversity had shaped their experience as college students, that they had learned from students of different backgrounds in the classroom and outside of the classroom, that this had impacted their long-term career goals and how they thought about what they wanted to do in the world, what goals they had and how they wanted to contribute as future leaders in society. They also spoke quite a bit about what it meant to have diversity within diversity on campus. And so this goes back to the idea of not just having diversity that tokenizes students of color, but rather having enough diverse students on campus that students can get some exposure to the reality that there's diversity within communities as well, and to be able to understand diversity along multiple axes. So you're not just thinking about diversity in terms of race, but the ways that intersects with class, with geographic background, with gender, with LGBTQ plus status. All of these things are interacting to form people's identities as they show up on campus, but also the ways that they understand and have experienced American society in terms of power, in terms of discrimination, in terms of the positive ways that their identity has shaped them. And so students talked about all these different aspects of identity in their testimony. And in particular, on the positive side, students also talked about the ways that their identity impacted the work that they wanted to do or why they had applied to Harvard in the first place. And they felt that being able to talk about that identity was really a critical aspect of applying to college, that they wanted the admissions committee to be able to understand how their racial or ethnic identity shaped who they were as an individual, but also as someone who could contribute to Harvard and who would contribute to the world afterwards. And that they didn't want that part of their application to be silenced or to be removed or to have admissions officers unable to consider this important part of who they are. And so that was really quite compelling. And I think it's really awesome to think about the ways that student testimony has shaped the record in this case, such that, you know, when this case went up to the First Circuit, that the panel who heard the case had to really grapple with what was in the record in terms of the student and alumni experiences. And hopefully, because it's in the record, it will also be something that the Supreme Court considers and grapples with when they think about these issues, that it's not just, you know, often that these terms can start to feel very theoretical, but there's real student experience that's shaped by diversity on campus as well.
Thank you. It's extremely important to center student voices. So I'm really glad to hear your discussion of this and really diving into that. And I also wanted to shift our discussion a little bit to talk about standardized testing. So studies have shown that standardized tests like the SAT and ACT are not reliable indicators of college success, and that these tests can be discriminatory towards students of color, English language learners, and students with disabilities. So I was hoping that you could talk a little bit about such claims, and specifically as it relates to the Smith versus Regents of University of California case.
Sure, and I also really have to commend the brief that the Legal Defense Fund and that the Lawyers Committee for Civil Rights filed and at all stages in the litigation, that really highlights a lot of these points and the research that is well established, showing that there is racial and socioeconomic bias baked into standardized test scores, that the SAT and the ACT actually undervalue the abilities of Black, Latino, low-income students, and some Asian American students as well in the aggregate. And this is in part because of the way these tests were historically developed, that they were normed based on the answers of white applicants without including Black, Latino, other diverse students in the norming process. And so there's that bias built in. There's also cultural bias built into the exams. For example, if you think about how verbal scores are given, they're often testing what vocabulary students have been exposed to, not academically in school, but outside of school as well. So one example that's often given is testing students about the term regatta, right? If you come from a city where there are not regularly regattas around you, it's not likely, you know, that you would have been necessarily exposed to that term, even if you are achieving in school and you know, really doing well in English and other courses that would prepare you to do well in the college setting. So that's another way that there's bias built into the exams. And so this research showing that exams are racially biased is well established, but there's also research showing that the tests are unreliable and that they don't predict how well a student is going to do once actually admitted to college, as well as, for example, looking at the GPAs of students. That's a better indicator. Instead, what standardized tests are most closely correlated with is the background of students' parents. the economic background and the educational background of students' parents. So that's what it's a very good predictor of, as opposed to how a student is actually going to do at college. One of the reasons for this that people may already be aware of is that standardized tests can be gamed, that through access to coaching, access to courses, you can improve your score. And the flip side of that is that if you don't have access to the resources to take these courses or to get coaching, your score is going to be lower. And so for students who come from low income background and don't have access to these resources, they're already at a disadvantage in the application process, regardless of how well they've done at school or their aptitude to do well in college. So these are different ways that the tests are biased. And it's really important to remember, because a lot of SFFA's argument relies on racial disparities in standardized test scores and their allegation that standardized test scores should be relied on more without acknowledging the bias that's built into standardized test scores. That argument, as it relates to Asian Americans, also overlooks that there's a real range in the aggregate scores of Asian American applicants, and in particular, Southeast Asian American applicants tend to not score as high on standardized testing for many reasons. And so to just say across the board that Asian American applicants would be disadvantaged by not considering standardized test scores more is just not a true statement. There's some groups of Asian American students, when you disaggregate the data, who experience educational barriers when it comes to their standardized test scores as well, and for whom a holistic admissions process is really important in order to ensure equity. And one of the cases that highlighted this is the University of Regents case that you were just mentioning. It's called Smith v. University of Regents, and it was a state court case that argued that the University of California discriminated against Black, Latino, some Asian American students with disabilities, students who are English language learners. All of this coalition of different students were discriminated against in the admissions process at the University of California because the university relied so heavily on standardized test scores, despite knowing the ways that these students were disadvantaged and that there was bias against them built into these tests. And ultimately, University of California ended its use of standardized test scores as a result of this litigation in part. And so, it's really important to remember as we're looking at these arguments that there's actual research showing that the data that is at the core of these arguments is actually biased against some students. One other point I just want to flag, because it often gets overlooked related to this, is that during President Trump's administration, the Department of Justice actually brought a similar case to the Harvard case against Yale University, arguing that students who apply to Yale, who were white or Asian American, were discriminated against in the admissions process because of how Yale considers race. And this goes again to the point about the need to disaggregate data. And in that case, the Department of Justice actually dropped a footnote where they said that for the purposes of their allegations and the claims in that case, Asian American did not include, and then they listed out different groups of Southeast Asian American students. So if you can imagine, they literally just tried to erase some groups, some subsets of Asian American students and say they aren't encompassed with that identity anymore. I don't know where the government gets the authority to do that, to redefine people's identities, but they did that for the purposes of their case because the data did not support the allegations that they were making for all Asian American students. And so they said, well, we'll just ignore it as it relates to some. And when President Biden's administration withdrew that lawsuit, Students for Fair Admissions refiled that lawsuit and remade those allegations. So this pattern of just ignoring the experiences of some Asian American students, and despite the data, continuing to pursue this narrative that race-conscious admissions discriminates against Asian American students writ large without considering, through an intersectional frame, the experiences of different students, is pervasive throughout the cases that they file.
Okay, and for our last question, I wanted to know what happens if affirmative action ends, and to get your thoughts on that, since we do have this upcoming oral argument on October 31st.
So there's two different ways we could think about this question, which, it's not a question that we don't have information about. First, during the trial, there was testimony and evidence that was presented on this issue. And it made clear that without race-conscious admissions, there would be a reduction in Black and Latino students on campus by about 50%. So that's really significant. And there was a lot of testimony about how that would impact students of all backgrounds on campus in terms of their ability to pursue the educational benefits of diversity. So we know that as a matter of the evidence that was presented at trial. And we even know that without race-neutral alternatives, there would be with even using race-neutral alternatives, there would still be a reduction in Black and Latino students on campus. And SFFA did not deny that. Their expert admitted that there would be a reduction of Black students on campus, even using, its suggested race-neutral alternatives by about a third. Rather, the dispute is just about whether or not that's significant. So there's no dispute about how the numbers would change. There's more just a dispute about whether that change matters for the purposes of pursuing the educational benefits of diversity. So separately, we also know from kind of the real world, quote unquote experiments about this from states where race-conscious admissions has ended, for example, in Michigan and in California. And we know that Black student enrollment in those places has decreased by as much as 25%, and Latinx student enrollment has decreased by nearly 20%. And that's according to a 2012 study by the Civil Rights Project. So from all of this, both real life experience and from the predictions that experts were able to reach during trial, we know that the impact of ending race-conscious admissions is going potentially to be, really significant if the Supreme Court reaches the conclusion that Students for Fair Admissions has asked it to reach and ends race-conscious admissions. In addition to that, I should say, the evidence that was presented at trial also showed that ending race-conscious admissions would not lead to a significant increase in the number of Asian American students on campus. Instead, it would lead to a significant increase in the number of white students on campus.
Okay, so there definitely is a lot at stake, and this conversation is just one of many conversations that students at Penn and the Penn community more generally can have. So Professor McClellan, I really want to thank you for bringing your wisdom and your insight to this discussion. And again, we hope that the Penn community can keep these conversations going, and we'll attach additional resources if you're interested in learning more. So again, we thank you for tuning in, and thank you, Professor McClellan.
Oh, thank you, Karla, and thank you for your tremendous research on these issues. Also, again, encouraging everybody to tune in to Supreme Court arguments on October 31st, and hope we'll continue the dialogue around these important issues for our country.